Welcome, everyone. It is Tuesday, August 20th. Today's topic is fair housing. The title is Housing Ever Fair on the Road to Fair Housing 2024? We're going to cover a few things today on this topic that seems to come up all the time for community associations here in Arizona. We're going to cover this topic from an Arizona perspective regarding the law as we understand it on August 20th, 2024. I've covered this topic over the years, going back really to the 1990s, and it evolves all the time. Usually, when lawyers cover this topic, we start with what are the protected categories? I'm not going to do that today. I'm going to do this a little bit differently. Something a little different. Why do we use the word fair? Well, the abode itself, kind of a strange word for the place you live, is that your house you own, it is the apartment you live in, is it the Airbnb that you live in, the hotel, the motel, whatever it is, the abode, the place that you sleep at night, eat your Cocoa Pebbles, your ham sandwich. The abode itself tends to be neutral. The time when it's not neutral is when you have a disability and the kitchen cabinets are too high above your head, you're in a wheelchair, something like that. But generally, for most people, the abode itself is neutral. But the structure is not neutral for people with disabilities. The challenge with fair housing tends to be the people, at least for us in community associations, the attitudes, behaviors, comments, things like that. So what is the public policy? What drives fair housing? And why is it maddening? Why is it frustrating for those of us in community association management? And by management, I mean professional community managers and lawyers that end up in the dispute side of community association work. And when you see the public policy behind fair housing, we'll see quite quickly why it's maddening. The public policy is that discrimination in housing is constant and pervasive by all housing providers. That's the public policy. Now, the public policy in fair housing was created in the 1960s. The view we have in America today is that not everybody, but the 1960s is when we emerged from a period of rampant racism. The Fair Housing Act was enacted in 1965, along with the Civil Rights Act. And this was the birth of we need to reform our country from a period of horrible racism and discrimination. And the Fair Housing Act was part of that. Well, we still operate under the Fair Housing Act. So it's not a surprise that the public policy has not changed. So the government employees, some call them bureaucrats, are charged with the same public policy that was enacted as part of the Fair Housing Act. And so HUD, the Department of Housing and Urban Development, is working under the same mandate. I'm not saying they're wrong, but the public policy hasn't changed in 60 years. So when board members and professional community managers are on the receiving end of enforcement under the Fair Housing Act, we just have to remind ourselves, this is the public policy. You might disbelieve the tenets or the public policy, but the notion that those tenets undergird fair housing policy in the US today is not a debatable point. That is the public policy. Here's what the HUD says. This is our federal government. Their website says, the mission of the Office of Fair Housing and Equal Opportunity, that's the office within the federal government, eliminate housing discrimination, promote economic opportunity, and achieve diverse, inclusive communities by leading the nation in the enforcement, administration, development, and public understanding of federal fair housing policies and laws. So no problem. That's what we receive the effort of the Office of Fair Housing and Equal Opportunity in community associations. It is their belief, the bureaucrats who work for the FHEO, that community associations discriminate in housing significantly and frequently, and that occupants of community associations are on the receiving end of discriminatory housing practices quite often. I covered this in a previous seminar back in June when I talked about animals in community associations. My effort today will be fair housing except for animals. So if your idea today was to learn a lot about animals, my entire talk on animals is available at my website, carpenter.law/seminars, and just scroll down and you'll see the one on animals. So here's what we don't do in community associations that the Fair Housing Act covers, which is significant. The Fair Housing Act cares about renting and selling housing. Generally, we don't do that in community associations, but every once in a while we do it. Take, for example, an association that forecloses its assessment lien against a delinquent homeowner. And at the end of the foreclosure lawsuit, the association wins an auction, a sheriff's sale auction at the courthouse steps, becomes the owner. And someone on the board says, you know what? Seems like people who are in the landlord rental business make a lot of money. We now own this unit. Let's rent it out. Let's become another one of the landlord rental folks in our community. Let's rent it for, I make it up a number, $1,800 a month. And we'll just be in the REO business, not REO Speedwagon, REO real estate owned. Let's be an association. We'll just own unit 30 and we'll make money on it. And when we own it free and clear, we traded our judgment for delinquent assessments for the unit. It's worth $250,000. We'll make $1,800 a month as income. So sometimes we do rent or sell housing. We're renting it for $1,800 a month in the hypothetical I just gave you. But when we're tired of that, when we're sick of finding renters and dealing with rental and tenant problems, believe me, there are plenty, not because I'm a landlord, because I'm not, but when you're tired of the tenants saying, well, the toilet stopped up and the sink and the water heater and the blah, blah, blah. Eventually now the association is going to be in the business of selling that unit. And now we have to sell it in compliance with fair housing law. We can't discriminate. We can't say, well, we want to sell it, but we want to make sure we sell it to somebody who's not that kind of person. We want to make sure it's somebody that's just like us. So generally, we're not in the renting or selling of housing business, but sometimes we are. What else? Generally, we're not advertising housing, but sometimes we do. Now, so far, we're not a big apartment complex renting housing. We're not a big home builder selling housing. We're not advertising either one of those things. But those that do build apartments and sell model homes and big communities, like perhaps where you manage or where you live, they obviously have obligations under the fair housing. Generally, we're not evicting people, but apartment complex owners, they do evict people and they have obligations under the Fair Housing Act. You can't just evict somebody because you don't want those people in the apartment. We're not advertising, as I mentioned, but advertising rules are actually quite specific. You think about some of the advertising you've seen for housing, whether it's an apartment complex or a new community, the racial mix of the advertising, the children on the playground, the people in the community, the racial mix of the advertising is actually diverse, intentionally so. There are regulations about that. And we're not providing mortgages, but there are really strict requirements about mortgages under the Fair Housing Act. There are two broad concepts under the Fair Housing Act that apply to community associations. And these also apply to apartment complex owners, but that's not my point today. We're a community association law firm here at the Carpenter Law Firm, and this is geared toward community associations. Reasonable modifications and reasonable accommodations. Two distinctly different concepts. We're going to divide this into two, and we're going to take them in order. We'll start with reasonable modifications. So under the reasonable modifications bifurcation, two roads diverged in a forest. One went to reasonable modifications, the other went to reasonable accommodations. Let's start with modifications. The modifications part of this is that an occupant, we'll use the word owner, is allowed under the Fair Housing Act, the Fair Housing Statutes and Regulations, to modify at the expense of the person requesting the modification to necessary to use it, enjoy the dwelling. This may be in the unit or the lot, or it may be on the common area. Now, the classic example is I need a ramp to get to my unit. My legs don't work anymore. I'm standing in my Carpenter Law Firm studio here at my stand-up desk. I'd give you a view of the whole situation if I could, but my camera's obviously in my studio here. My legs work, but if I needed a ramp to my unit, the association's obligated to allow me to make that modification at my expense. Now, the whole theory of the Fair Housing Act and the regulatory structure is it's no big deal if I pay for it. It's sort of a everything works perfectly on a whiteboard kind of situation. The way the whole regulatory structure works is imagine a bunch of bureaucrats at a giant whiteboard in Washington, D.C., and they're thinking about disabled people and modifications to apartments, apartment clubhouses. And somebody said, well, what about community associations? What about condominiums right here in Washington, D.C.? What about Alexandria, Virginia? What about Maryland? And then somebody said, well, what about condos in Chicago? What about Los Angeles? And nobody's thinking about Arizona, and they're all the same anyway. That's kind of how it all works. And somebody else in the room in this giant conference room in Washington, D.C. on the whiteboard said, well, doesn't it work if the owner pays for it and promises to put it back when they're done? What do you mean when they're done? You can kind of see the conversation happening. Well, when they move out or when they get sick and die, they have to put it all back. What do you mean put it back? You know, spackle the holes, remove the ramp, replace the landscaping, just make sure it's all put back the way it was before they put the ramp in. Yeah, I guess that probably does work. You can kind of see how a bureaucrat who doesn't really understand our world could say, well, yeah, I guess that cures all the problems if the modification is at the expense of the disabled person requesting the modification. So what if it's on common area? So what if it's in the unit? And if they have to put it all back when they leave, sell their unit, end their tenancy, or die, or whatever, hate to be that morbid about it. And so the classic example we use is they need a ramp to the unit to ramp up the stairs. And then you get these examples that I've heard from the national conferences I attend, where the 500 or so community association lawyers across the country get together and we teach each other and talk about our experiences. And all of a sudden somebody says, well, I need my own elevator to get to the pool on the roof of the condo in Chicago, because there's no elevator to the roof. I need my own elevator. I'll pay for it. I'm rich. But it requires that the association put in some power or something. Not that rich. And then all of a sudden the association says, well, we would never have done that. Well, those are complicated questions, and not prepared to answer them all today. So reasonable modifications at the expense of the person requesting the modification. Here are some problems I've had over the years with clients where it's not always so simple. What about the blue button to open the door to the clubhouse? I had a case a number of years ago where an owner said, well, I'm in a wheelchair and I want the association to put a blue button on back then it was a blue button, just, a button to open the door to the clubhouse. And the association disliked this individual significantly. It was personal. It was an emotional response because this disabled person in a wheelchair was a disagreeable person. And the board said, he's rude, he's mean, he's demanding. When he comes into the clubhouse, he yells at the manager and he's mean. And we don't want to do anything that he wants. So we ended up in this facilitated mediation with the Civil Rights Division of the Attorney General's office. And at the end of the day, all he really wanted was the blue button so that he could ride his motorized wheelchair up to the door of the clubhouse, hit the button so that he could get into the clubhouse without assistance. And he was willing to pay for it, which obviously makes sense. But wanted the association to pay for it. And the argument that I made, really not against my own client, but just when we were meeting without the mediator, I said, a lot of people would like the blue button, able-bodied people who have their hands full carrying things into the clubhouse for whatever reason. Many people open the door with the blue button, even though they're able-bodied. That would be an oversight by the builder developer to not have that in from the beginning. That's a standard feature of most buildings that should have been put in at the beginning. So when a homeowner says, I would like to be able to have a blue button to open the door to the clubhouse, it probably should have been there from the beginning. So could you make the homeowner pay for it? Perhaps. But generally I tell my clients it's a feature that probably should have been there from the beginning. Grab bars in the clubhouse bathrooms. Again, probably should have been at least one stall with those installed from the beginning from city requirements, because most new construction would have required that as a condition of city approval. But older construction wouldn't necessarily have that. And again, it begs the question, what's fair to the owner? So one of the other things that we have to keep in mind is every day we all get a day older, and eventually we'll all need it. One of the things that It's not a struggle necessarily, but every time I get together with my dad, I realize every day he's getting older. He's now 81 and moves a little slower every time I see him. And, he was always my ex-football player dad who could always throw a football farther than I could ever dream of throwing it. And every time I see him, I realize he can't throw a football the way he used to. And sure, if I asked him to, we'd go outside and he'd try to throw it. But um, given a choice, he'd go into the bathroom and use the stall with the grab bars. And I'm not trying to be weird about it, but if you have if you have an owner who wants grab bars in the clubhouse bathrooms, that's a feature the association should have anyway, because every day we all get a day older. Same with the blue buttons. Those are features the association should have anyway, and how that happened without it being part of initial construction is probably because it's an older association. All right, let's talk about moving parking spaces around in a condominium. And I'm going to come back to this because it's one of the more maddening problems that we face in dealing with um, the fair housing. So this is to be dealt with here in a few minutes. Moving parking spaces around. This is almost like an accommodation. This is a reminder that I'm going to come back to it. All right, let's talk about prohibited things you can't do in a modification scenario. This is HUD's position. You cannot say to an owner, we'll let you have your ramp if you pay for liability insurance. We'll let you have your ramp if you comply with the following aesthetic standards. If you make sure it looks perfectly in line with this or that. Am I saying that it has to look terrible? Not necessarily, but HUD is very clear that the owner gets to have their ramp. And when the association says you can only have your ramp if ... the aesthetic standard is as follows. That's a real problem for HUD. The association cannot say you can have your ramp only if you use ABC contracting. I'm making that up. You can only have your ramp if you use the following construction style. It has to be Santa Barbara construction. I'm making that up again. You can only have your ramp if you use the following accessibility standard, something like that. So HUD's very clear that you can mess this up quite easily. And it's also easy to see that a board could fall into one of these traps quite easily. And it's also pretty easy to see that a professional community manager could fall into one of these ruts pretty easily too. Well, we have our standard policy that anyone who has an outside vendor has to have liability insurance, and we have our design guidelines, and the design guidelines really apply to bullet points, aesthetic standards, and et cetera, et cetera. These are traps for the unwary here. So we've got to be very, very careful. Now, how many ramps do we see for wheelchairs in townhomes and condos in a year in Maricopa County, Pima County, and Yavapai County throughout Arizona? I don't know. Is it hundreds and thousands? No, it isn't. But when it does happen, we have to be careful because it's a high likelihood that when we mess this up, it's going to end up in a dispute posture that could very well lead to litigation and an investigation. So the modification part of this is somewhat overlooked, and we've got to be very, very careful. All right, let's talk about parking spaces. I knew I was coming back to it. So the unique challenge of parking space reassignment. Had a lot of disputes over the years where associations get into a lot of trouble with parking space reassignment. If the parking spaces are owned by the association, meaning the association owns the parking spaces, then the scenario is straightforward because the owner has a fair claim to space reassignment. Here's what happens. The disabled person comes to the board and says, I'm disabled. I'm a vet. My leg is gone. I just had it amputated at the VA and I'm down to one leg. And my prosthetic leg will not be ready for, let's make something up here. It's not going to be ready for 18 months. I need to be parking closer to my unit. There is a space close to my unit, but right now there's an F-150 that parks in that space. It's not mine. Right now I'm driving a Honda Civic. I'm making this up. In this hypothetical, I'm the vet. I'm going to have one leg for 18 months until my prosthetic is ready. I don't even know if that's how that works. I'm just making it all up for the purposes of this hypothetical. And I want to park next to my unit. I want space number 5. Right now there's an F-150 in it. And in this hypothetical, it's a planned community, meaning the association owns the entire parking lot and space number 5. The board of directors could, in theory, assign parking space number 5 to me, the vet, for 18 months, in theory. That might feel fair, that I could go to the association and say, I want space number 5 for 18 months until I get my prosthetic and become proficient with my prosthetic. And then maybe I can go back to space number 57 and walk the distance from over there and get to my unit. Assuming in this hypothetical that all of the parking spaces are owned by the association because it's a planned community. Sometimes people say, well, planned community, condo, what's the difference? Maybe it doesn't matter. Well, it actually does matter in these parking space allocation questions. It's like, well, the association maintains the roof and the exterior of the units. Is it a townhouse? Is it a condo? Is it a planned community? Well, it matters for this. If the parking space is owned by a unit owner, a deeded interest, how can the association kick out one owner and insert the disabled owner? So same situation as what I just outlined, but in that situation, the unit owner owns lot 5 and owns parking space 5. So when I come along and say, hey, I'm a vet, I've just had my leg amputated, it'll be 18 months before I get my prosthetic, I want space number 5. Well, the board goes to the F-150 owner who's parking in space number 5, and he says, well, I own space number 5. I've got a deed. It's part of my ownership. I own lot number 5, and I also own parking space number 5. I have a deeded interest. Now, the owner of space number 5 does not have to say, I bought it from the developer. He doesn't have to use that sentence. He can say, I own lot 5, and here's a legal word we use sometimes, and appurtenant to lot 5 is parking space number 5. Maybe it's connected to the deed. Maybe it's lot 5, and appurtenant to lot 5 is space number 5. A lot of different ways that can happen for it to be connected. It can be connected any number of ways. Legally, Sometimes developers do these things in a neat and tidy way. Sometimes developers do these things in a sloppy and messy way. Sometimes developers take money from buyers and tell them verbally, you bought lot 5 and parking space number 5, and then they don't document it. They just say it. And then they take money. They take money for lot 5, and they take an additional sum of money for parking space number 5. There's no documentation. Nothing's recorded with the county recorder. And then there's just what we call the lore, LORE, where people say, well, I bought parking space number 5. And then the lawyers like me come along and say, well, where's the paperwork? There's nothing recorded at the county recorder that says you own lot number 5. And we figure all of this out in the context of what you see on your screen right now. Disabled person comes along and says, I want space number 5. And somebody says, well, I own space number 5. And I say, do you now? Why do you think that? Well, I paid the developer a bunch of money. Developer took the money and told me I owned space number 5. Okay, you did a deal. You gave money to a developer who told you you owned space number 5. Do you have any paperwork? Do you have a deed? Nothing's recorded at the county recorder. And now we have to move you to space 37 so that the disabled resident who's got 18 months before the prosthetic leg comes in is going to use your space. And now the owner of space number 5, at least in his mind, is thinking, I'm a dupe. I paid money for this space. I've been using it for 5 years. I didn't get any paperwork. And I'm mad at my realtor because I'm a dupe. Paid for a space, no paperwork, nothing recorded at the county recorder. And that buyer, along with everyone else who paid for a parking space and got no documents, now the whole association realizes it's a mess. Happens all the time. And by the way, that's not the professional community manager's fault. Managing a community where people think they own their parking space, but there's no paperwork and no documentation, that's nobody's fault who's currently involved in management. But when the disabled person comes along and says, I want space 5, I want space 4, I want space 1 because it's close to my unit, and we, current community association attorney and current professional community manager, have to decide, must we accommodate the disabled person by putting their parking space close to their unit? The answer might be yes. If the person we have to move does not own their space. It's not just about ownership. It's also about the person who has to be moved having a right, RIGHT, to their space. And they might have a right to their space that's not just about owning their space. Here's another way of looking at it. HUD and the Civil Rights Division of the Attorney General's office investigate these issues basically on the assumption that condominiums can reassign parking just like an apartment. That's the way they think. They think, well, what would happen in an apartment? Vet loses a leg or has a leg removed and has 18 months before the prosthetic comes in. I don't know anything about how long it takes to get a prosthetic. It's probably more like a week, as far as I know. And so I'm just making things up to make my legal point here, folks. Vet lives in an apartment, goes into the office and says, I want to park next to my apartment. And the apartment says, can't do it. So the vet goes to the Attorney General's office or HUD and says, I want to make a complaint. I'm not being accommodated in my disability. Here's what's happening. Here are the pictures. Here's my vehicle. Here's my apartment. Here are all the spaces. And the apartment will not accommodate me or modify my parking reasonably. The Attorney General's office and the Civil Rights Division are going to say, you've got to be kidding me. And so because of the attitude at the Attorney General's office and at HUD about apartments that could, because nobody owns a parking space at an apartment. Tenants do not. The apartment owns all the spaces and can reassign people anytime, any way they want to. So when it comes to the government's attitude about parking in condos, they see it the same way. That's what we're up against. So when we explain to them, no, the person parking in space 3 owns space 3, if that's in fact the case, sometimes it's hard for them to understand. So if I own my space, the board cannot move me so easily. All right, let's talk about reasonable accommodations. This is the two roads diverged in a forest. This is the other road, accommodations. Here's HUD's position. This is accommodating rules and policies and CC&R sometimes. If the board makes an accommodation and if it's approved promptly, and this is what HUD requires, the process is completed. And here's what you're up against. If the requested accommodation is questioned or denied, then there are more steps. And this is where associations get into trouble. If the accommodation is questioned, if somebody comes to you and says, I want a closed parking space, we'll stick with that scenario for a moment, then you have to engage in what's called an interactive discussion process between the housing provider, which is the condo, and the person with the disability to explore whatever is at issue. Now, this interactive discussion, HUD wants that to be in person. And in an apartment, this feels like, the disabled person's going to go sit in the office and have this face-to-face discussion. We need to do that also. HUD says sometimes the discussion is about whether the accommodation is related to the disability. Sometimes it's about the burden of making a particular accommodation and the possibility of other less burdensome alternatives. Well, in the case of the parking, there is no less burdensome alternative than parking close to the unit. If an accommodation is denied, it can only be because it would be an undue financial and administrative hardship or a fundamental alteration of the housing program. Those are the only ways you can deny a requested accommodation. If you do deny the accommodation, there still has to be an interactive process to identify whether there are alternative ways to meet the needs of the disabled person with less burden on the housing provider. So this is tricky when it comes to reasonable accommodations, because this interactive process is something that very few associations actually do. And what it really requires, and it's expensive, is it almost is the Attorney's Full Employment Act, because whenever somebody requests an accommodation, it's hard, it's difficult to navigate this multi-pronged back and forth without getting legal advice along the way. And so it's difficult and expensive, and you don't get to make an insurance claim on your D&O insurance just because someone has requested an accommodation. So you're kind of in the unfortunate position of being in the hourly legal fees world just to navigate the interactive process. It's frustrating and almost unavoidable. Or you have to essentially approve all accommodation requests. And that almost never happens. It's extremely frustrating. So here's the standard. A reasonable accommodation in rules, policies, practices, or services has to be made when the accommodation may be necessary to afford a person with a disability equal opportunity to use and enjoy the dwelling. It's not just the abode, it's the clubhouse, the facilities, everything about the programming. So sometimes this includes the ability to attend and participate in the annual meeting. That's included in use and enjoy the dwelling, is to understand what's happening with the association and participate in the governance. So you have to reasonably accommodate any disabled person and whatever's necessary to give them an equal opportunity to use and enjoy the dwelling. That would include the pool. We've had cases over the years that include a lift to get into the pool, the blue button to get into the clubhouse, all the things that I've mentioned, a reasonable accommodation and rules, policies, practices, or services. These accommodations are reasonable. There's really no getting out of this by saying, well, what does reasonable mean? I mean, you could look at that and say, well, we'll just avoid having to do any accommodations that are not reasonable. Our safe harbor will be, we'll decline anything that's not reasonable, and we'll just deem requested accommodations that are unreasonable, and we'll just say no to those. Let's see if there's much room for that. Accommodations are legally reasonable if they are practical and feasible. The law says not every requested accommodation has to be approved. If it's unreasonable, it is unreasonable if it would impose an undue financial and administrative burden or constitute a fundamental alteration of the housing program. So if we look at the blue button, for example, a blue button is not just a blue button. There's electrical that has to be pulled to a pedestal, and then there's an arm that has to be installed on the door itself. And let's just make up a number. My name is Carpenter. I'm not a carpenter. I'm not in construction. But you'd be surprised how many emails and phone calls I get about, hey, we want to bid for custom cabinets or something like that. You wouldn't be surprised at how many people think I'm a tradesman. Would be nice, I guess, if I could be multi-talented, but let's just make up a number and say that to install the blue button on the door to the clubhouse, let's just make up a number, and I have no basis for this. Let's just say it's $10,000. And let's assume that an association with the clubhouse has a annual budget of $3 million. If that's true, then we would have a tough time saying that 10,000 out of a $3 million budget is an undue financial burden. And for an association with a clubhouse and a $3 million annual budget, the administrative burden of overseeing that contract, when that contractor is going to be there for couple, 3 days at the most, I would think. And having a blue button would not fundamentally alter the housing program. That's a very small contract. And being there for a couple of 3 days where the door is going to be open and closed for a couple of 3 hours in the aggregate over a couple of 3 days, we cannot argue with a straight face to a mediator or to the Civil Rights Division of the Attorney General's office that 10 grand may be paid by the owner. Go back 30 minutes of this conversation, but even paid by the association is an undue financial burden or administrative burden, or that having a blue button on the door to the clubhouse, which should have been there from the beginning, is a fundamental alteration of the housing program. Should have been there from the beginning. I'm in a 3-story office building in Gilbert and Guadalupe. To my surprise, the main doors to this building on the first floor do not have blue buttons. I've been carrying junk into this building for the last several months, and I wish there was a blue button. I don't know how or why there's no blue button. So I care about the blue button, but it's not an undue financial burden, and it does not fundamentally alter the program. And you could use a lot of different examples for how difficult it would be to argue that an accommodation is unreasonable. You could kind of see my point. All right, let's go back to I said I wasn't going to start with the protected categories. I was going to bring it up later because in fair housing presentations, we always start with the protected categories, but I'm going to back into it this time. All right, here we go. Race. You cannot discriminate based on race. Purple people, you can't say no purple people. You can't say no Black people, that kind of thing. Color, national origin. I like this one because you might look at somebody like me and say, well, he's a white male and he's not in any category. So absolutely I am. In fact, I'm in multiple categories, and the white male patriarchy is actually in multiple categories. I'm not actually Canadian, but I can maybe mimic some of my Canadian friends, but not very well, actually. I'm actually bad at accents and bad at mimicking. My wife's much better at it. But national origin, somebody could say, we don't want any of those Canadians here, and that would be discrimination based on national origin. Religion, somebody could say, no Muslims, but we don't want any of those people here. That's protected. Sex is protected, male, female, or non-binary, or anything in between. Sexual orientation is protected. It's not in the statute, but there's Supreme Court case law that includes it. Gender identity, again, not in the statute, but US Supreme Court case law includes it. And then familial status is in the statute. This means whether someone is married or not, or whether someone has children or not. So these are the protected categories. And, we kind of back into it here toward the tail end of our discussion. And, and disability, we talked about that some today in terms of, the accommodations and things like that. But discrimination in housing really started here with the Fair Housing Act in the 60s. These were the obvious things that we were dealing with as a country. And so these were the categories that were created then: race, color, national origin, religion, sex, and familial status. Sexual orientation, gender identity added within the last 4 years by US Supreme Court case law. So some modern questions and problems. My PowerPoint's freaking out on me a little bit here, but let's start with this. What are we doing with our bathrooms? And I'm not trying to, get weird on you here about transgender, but this could happen where in your clubhouse, a woman encounters a man in the women's restroom in the clubhouse and comes to the community manager and says, there's a man in the women's restroom. What are you going to do about it? And this has happened to a few of my clients where the manager says, "Oh my goodness, I was completely unprepared for this." Karen-esque encounter where someone came to the front desk and said, "What are you gonna do?" There was a man in the women's restroom in the clubhouse. It's more of a management. I'm not trying to avoid the question, but it's kind of a management company problem in the sense that managers have to be trained and prepared for dealing with kind of a people problem of that. So there's a challenge there that we haven't really been completely prepared for. And it does raise the question, what is the legal obligation of the association in terms of prepping our restrooms? Well, what the law says is generally under federal law is that people, especially with the inclusion of gender identity as protected in housing, is that people can choose the restroom that aligns with their gender identity. So the presence of a man in a women's restroom is acceptable if the person is there because the presence is because that restroom aligns with the person's gender identity. But just because the person's in there doesn't necessarily mean that the person is there because that restroom aligns with the person's gender identity. Someone could simply be in the bathroom to do a bad thing. We can't forget that. Someone could be in the bathroom to commit a crime. And there's a difference between someone being in a bathroom to commit a crime and someone being in the bathroom to use the facilities and being in the bathroom because it's been selected because it aligns with their gender identity. And you're probably thinking, well, geez, how am I supposed to know that? I'm a professional community manager. I've got somebody telling me there's a man in the women's restroom. How do I know if the person is there to commit a crime of opportunity or if the person is there to use the facilities because that's the room that aligns with their gender identity? Now, frankly, I have no idea. I really have no idea. You can't just go up to a person and say, are you in there to commit a crime? Or are you in there to use the facilities because you are selecting that restroom because it aligns with your gender identity? I mean, geez, how easy for me to make it sound so simple. Hey, dude, are you there to commit a crime or are you there to use the facilities because that's the restroom that aligns with your gender identity? I mean, I should get negative 10 points knocked off my score for today just for pointing out such a stupid question. I know it's dumb, but that's the state of affairs when it comes to restrooms in community associations. People are allowed to select the restroom that aligns with their gender identity, but I know it puts professional community managers in a terrible position because a person's not allowed to go into a women's restroom to commit a crime. And where this really creates problems is for the association's insurance carrier the guy goes in a women's restroom and commits a terrible crime, and then the victim's family files a lawsuit against the association, the insurance carrier is kind of left in a bad position. So no great solutions there, but these are questions and problems. That's the name of the slide. Let's go to neighbor input on architectural matters. Many associations, despite what we've been saying for many, many years, still ask neighbors for input on architectural submissions. Here's why that's a problem. There's an architectural submission on lot 10, and the association board or architectural committee says, well, we're going to ask everybody around lot 10 if they have any thoughts or ideas or input on this submission. Well, the people around lot 10 may have negative views of the owners of lot 10 based on the owners of lot 10 and their race, color, national origin, religion, sex, sexual orientation, gender identity, or familial status. And the board might not know that. But the neighbors all around lot 10 may have unexpressed feelings about the owners of lot 10 based on their race, color, all of these things. How they view the universe, their religion, their sexual orientation, gender identity. And then when it comes time for those neighbors to say to the board how they feel about the architectural request, those secret feelings about those protected class categories might come out as, please deny the architectural request. What the board has actually done is provided the neighbors with an opportunity to engage in what's called hostile housing harassment. The board has essentially delegated its decision-making power and given the neighbors a veto over the architectural matter, which begs the question, can the board seek and receive input at all? It's one of the reasons why for years I have said, please just stop doing this. Just don't do it. Just make the decision. The architectural committee and the board should just make the decision. Don't ask for neighbor input. It's not necessary under the law. Just make the decision and move on. My April seminar was on neighbor versus neighbor challenges, and I covered this topic of hostile housing harassment. So today's been on fair housing, but I've got two previous seminars on a few of these subtopics. So the third modern question and problem that I'll highlight on our way out here today is harassment generally. Every person is in at least one of the categories all of the time. No one is in no category because everybody has a national origin at a minimum. Everybody was born somewhere, and last I checked, everybody has a nation of origin, at least they should, unless you were born on a ship, I guess. Every owner can say, I'm being harassed because I'm in category X, and the association has to stop the harassing conduct. The obligation to stop the harassing conduct is something I highlighted in the April 16th Neighbor versus Neighbor Challenges seminar. HUD had guidance from a few years ago. It's still the law at the end of the Trump administration. I'm sorry, at the end of the Obama administration, I should say, that the housing provider is obligated to end the harassing conduct, the community association, I should say, is obligated to end the harassing conduct. When an owner says I'm being harassed and they go to the association and say neighbor to neighbor harassment is occurring based on a protected classification, the association is obligated to end the harassing conduct. So when this happens, the association has to figure out a way to end the harassing conduct. So these are the modern questions and problems we see quite routinely. All right, this is what I had for today. I've got a few questions. Karen asked, what if the modification is to the common areas? Same answer. An owner is permitted under the law to modify common areas when disabled in order to fully use and enjoy the dwelling. If the person is simply elderly but not disabled, that would be the same answer. It's hard to be elderly and not disabled in at least one way or another. So I shouldn't have said that way. If the modification's required to use and enjoy the dwelling, then we have to accommodate it, whether it's the modification or the accommodation. But like I said about my dad, once you get to a certain age, the body breaks down. So if they're elderly and they want a modification, they're breaking down. It'd be hard for someone to say, my body's doing just fine, but I need a modification, but I don't really need it physically. Can the association control the installation of the modification if it is to the common area? No, my bullet points, let me go back. HUD's very clear. These prohibited modifications apply regardless of whether the modification is to the common area or to the unit. And this is a very good point. That's frustrating because when someone's on the common area or common elements, this idea that the owner wouldn't have to have liability insurance kind of gets our ears perked up. We would always be concerned about that or whatever else. Vanessa asks, our committee asks for neighbor consent when making wall modifications or if there's a variance from required setbacks. Is this the same thing as requiring neighbor input? I'm always concerned about situations where the discretion that the documents give to the association to make architectural decisions is delegated even just a little bit to a neighbor, where if one neighbor says no, then that becomes an overall no. That just feels like the owner that says no could have any number of motivations. And that makes me really, really nervous. And I've seen it happen. A number of years ago, I had a case where an association said to an owner, you can have a driveway extension to the property line where the driveway, on the short side of the driveway, you can have an extension of the concrete to the property line if you get the next door neighbor's consent. She tried. The next door neighbor said no. Then she, who was Hispanic, went to the Attorney General's office, Civil Rights Division. We went to a mediation. And she said, well, I'm Hispanic and I'm a single mom and I think my neighbor hates me and I think it's because I'm Hispanic. Right here, any of these three or all of these three. Was she right? No idea if her neighbor was racist or not, but the only party in the room was the association, who was accused of enabling her neighbor's harassment The neighbor was not there. It was just the Hispanic woman and the association. The association was accused of enabling the neighbor's harassment through the policy of requiring neighbor consent for something as simple as requiring his yes or no. He said no to a driveway extension. Well, she had pictures of a dozen other driveway extensions throughout the community. Of course she did. That's how these things work. And what we found in the course of the mediation, because I had my board members there, is that if she had requested to go up to an inch away from the property line, it would have been approved, but it was the act of going up to the property line. Well, we settled and said, okay, just don't go up to the property line. And we walked out of there an hour later. And it was a troubling matter, but because the board said, we're letting the neighbor decide. The neighbor gets to decide. So I guess that's kind of what I'm saying. And so this question is a good one. Whenever you ask for neighbor consent, and then ask yourself the question, if the neighbor says no, we're going to say no. If that's what we're doing, that's where I'm troubled, because when you go through the list and you ask yourself the question, if the neighbor has trouble with any of these things, would we know it? Would the neighbor ever admit it? But if secretly the neighbor has trouble with any of these things, we wouldn't know it, but we would be an unwitting party to discrimination based on these things, because we're letting the neighbor say no, and then we're saying no. That's what I'm trying to say. So we just have to integrate that into our thinking, and the government's onto us. Larry asks, is any proof of an accommodation request required? Well, the owner's making the accommodation request, and then we're acting on it. And that's where we have this interactive requirement. And, if a tree falls in a forest and nobody hears it, doesn't make a sound. If they make the accommodation request and we don't do the interactive process, and they never complain to the government, no one will ever know that we didn't do the interactive process. This is where I'm talking about the unfortunate reality of legal fees. When somebody makes an accommodation request and you don't hire lawyers early on, you may not do the interactive process with the owner. And then when they do make a complaint, it's going to be hard to document the interactive process you did go through. But it's a risk we're taking for a lot of associations, because a lot of associations don't undertake the interactive process and get away with it, because not everybody who wants an accommodation files a complaint. And so it's a risk that some take. So there we go. That's the third of 3 fair housing seminars that we've done here at the Carpenter Law Firm. This one, plus the one that I have here, and then the one that I did on animals, which I don't have linked here, but is on my website, carpenter.law/seminars, under the past seminars grouping at the bottom of the webpage. Thank you for spending some time with me this afternoon on August 20th, 2024. I will see you in September. I believe it's September 17th. Have a great rest of the day and rest of the week. Thank you.